Judicial review, origin and meaning. In India, the legislature, the executive, and the judiciary are the three organs of the government with distinct powers, which are embodied in the Constitution. The judiciary is entrusted to keep a check on both the organs to make sure that the laws legislated and the laws implemented are not ultra vires to the Constitution. To make these organs function within their specified limits, it is essential to have the feature of separation of powers, which is embodied in Article 50 of the Indian Constitution. The word judicial review came up before the court in Dr. Boham case. He was fined and forbidden to practice as a doctor in London as he was not having a license for the same. The word judicial review was summarized in Marbury versus Madison case in 1803 in United States. John Marshall was the Chief Justice of the United States Supreme Court. Judicial review is the power of the judiciary to declare legislative enactments and executive orders of both the central and state governments as unconstitutional if it goes against the basic principles of the Constitution. The enactments and orders which are invalid or null and void cannot be enforced by the government. The power of judicial review is vested in many articles in the Indian Constitution, which are as follows: 13, 32, 131, 136, 143, 226, 145, 246, 251, 254 and 372. Importance of judicial review. Why is judicial review so important? Let us see why it is essential. First point, it is essential for maintaining the independence of the judiciary. Second, it is necessary to protect the fundamental rights. Third, it is essential to balance the powers between the center and the states, thus keeping the federal balance. Fourth, it is essential for preventing the misuse of powers by the legislature and the executive or the administrative organ of the government. Fifth, it is necessary to uphold the supremacy of the Constitution. Sixth, it prevents the tyranny of executives. Seventh, it adjusts the Constitution to meet new conditions and needs of the time. Eighth, it serves as a redressal mechanism for grievances related to unfairness of a decision by law. Some of the observations of the Supreme Court with respect to the significance of judicial review are as follows. Chief Justice Kania pointed out, in India, it is the Constitution that is supreme, and that a statute law to be valid must be in conformity with the constitutional requirements. And it is for the judiciary to decide whether any enactment is constitutional or not. Chief Justice Patanjali Shastri commented, Indian Constitution contains express provision for judicial review of legislation so as to its conformity with the Constitution. Thus, the founding fathers realized the importance of judicial review, and so they incorporated it in the Indian Constitution. Scope of judicial review. The constitutional validity of a legislative enactment or an executive order can be challenged in the Supreme Court or High Courts on three grounds. First, it infringes upon the fundamental rights guaranteed in the Constitution. Second, it goes beyond the capacity or power of authorities that has framed it. Third, it infringes against the provisions embodied in the Constitution. The scope of judicial review in India is narrow when compared to United States because the Indian Constitution emphasized on procedure established by law rather than due process of law. In India, the Supreme Court, while determining the constitutionality of a law, looks whether the law is within the powers of the authority concerned or not. The Supreme Court examines on substantive question and does not go into the question of reasonableness and policy implications. The judicial review by the American Supreme Court in the name of due process of law has made the critics to describe it as a super legislature. The American principle of judicial review is adopted in a limited manner in our Constitution. Similarly, parliamentary sovereignty adopted from Britain is limited due to the written character and federalism adopted in our Constitution. Thus, there is a synthesis of the American principle of judicial supremacy and the British principle of parliamentary supremacy in our Constitution. Features of judicial review. The features are as follows. First, judicial review of both state and central laws. All laws, orders, bylaws, ordinances and constitutional amendments of the center and the states are subject to judicial review embodied in Article 13(3) of the Constitution. Second, judicial review exercised by Supreme Court and High Courts. Under Article 32, a person can move the Supreme Court, and under Article 226, the High Courts for violation of fundamental rights or for a question of law. But the power of interpreting the Constitution lies with the Supreme Court, and its decisions are binding. Third, principle of procedure established by law. Judicial review is established by the principle of procedure established by law as given in Article 21 of the Constitution. The law has to pass the test of constitutionality. Fourth, judicial review is not applied automatically. The Supreme Court cannot itself apply for judicial review. That is, it can be used when a question of law or rule is challenged before the court. Fifth, judicial review not by suo motu. The Supreme Court or High Courts do not use their authority to conduct judicial review by suo motu. Functions of judicial review. The judicial review has two functions. First, to make the actions of the government legitimate. Second, to protect the constitution from any encroachment by the government. Types of judicial review. The doctrine of judicial review is the interposition of the judicial restraint on the legislative, executive and judicial actions of the government. It has gained the status of permanence through judicial decisions which were laid down from 1973. Judicial review has become the basic structure of the Constitution, and any act, or at least to destroy or damage the basic structure, is unconstitutional. Justice Syed Shah Mohammad Qadri classified judicial review into three categories. They are as follows. First, review of judicial decisions. This review is used to rectify amendments in previous findings or judgments by the judiciary itself. For example, L.C. Golaknath versus State of Punjab 1967, Minerva Mills Limited versus Union of India 1980. Second, review of administrative actions. This review is a mechanism of enforcing constitutional discipline over administrative agencies. Writs under Article 32 and Article 226 of the Indian Constitution provide relief against misuse of power by administrative authorities. For example, A.K. Kraipak versus Union of India. Amit Kumar Sharma versus Municipal Corporation, Chandigarh 2021. V. Saminathan versus the Government of Tamil Nadu 2021. Third, review of legislative actions. This review determines that the law enacted by the legislature are in accordance with the laws laid down in the Indian Constitution. For example, Rajendra N. Shah versus Union of India 2021, Justice K. S. Puttaswamy versus Union of India 2016. Reasons for the growth of judicial review. Why is judicial review so popular? The reasons are as follows. First, check. Judiciary ensures proper check on the exercise of public power. As a result, people have great faith in the judiciary. Second, awareness. There is a growing awareness among the people about their rights. Third, scrutiny. Judiciary scrutinizes government's action. As a result, there is increased confidence in the judiciary. Fourth, judicial opinions. The executive seeks judicial opinions on various matters to avoid its accountability for the decision they take. Fifth, non-traditional areas. The judiciary has ventured into non-traditional areas, that is, areas which were not part of the judiciary. Limitations of judicial review. There are certain limitations on the exercise of powers by the Supreme Court as well as the High Courts. First, sets a precedent. The judicial decisions of the judges serve as the basis for ruling in other cases, thus acting as a precedent. Second, separation of powers not followed. The concept of separation of functions is followed rather than that of separation of powers. In spite of this, there is a provision of checks and balance where the judiciary has the power to review laws passed by the legislature. Third, selfish motives. Judgments may be influenced by personal or selfish motives which harms the public at large. Fourth, lower courts do not enjoy power of judicial review. Higher courts like the Supreme Court and high courts only enjoy power of judicial review and not the lower courts. Fifth, repeated interference. People lose faith in the efficiency and integrity of the government because of repeated court interference. Sixth, restriction. The court must rule on constitutional matters only if necessity requires it to do so. Thus, the judiciary has to follow the doctrine of strict necessity. Seventh, violation of limits set by the Constitution. The legislative powers are violated when the judiciary overrides any previously established law by the legislature. Eighth, limits executive. Judicial review interferes in the executive mandate, thus limiting the functioning of the executive. Ninth, practical. The nature of judicial process brings practical limitations on what courts can do. Judicial review has become a part of the basic structure of the Indian Constitution. It safeguards the fundamental rights, balances the power between the center and the states, defines the functions of every organ of the government, prevents use of arbitrary power and miscarriage of justice, is the guardian and protector of the Constitution. Thus, judicial review has grown to safeguard the individual rights, to stop the use of arbitrary powers, and to prevent the miscarriage of justice.